Good afternoon, everybody. Not legal advice. Please like, subscribe, share, comment, barf, whatever you're going to do. Saying hello to who I see. Who do I see there? Mr. StreamYard. Hello, Mr. StreamYard, my most ardent fan. Born to Free Films, Donna, PJ, Renee, Rondell. Hello there. To all of you out there, wherever you are, hello, hello, hello. Um, I needed to do this because I thought it was significant enough in my mind that it required to be put forth. Now, you might think whoever you are, might feel differently, and you are entitled to feel differently. And if you don't think that whatever I'm going to tell you about today, if that if you think differently, then that's great. If you think along the lines that I do, or if you hold the concerns that I do, then I'm going to ask you to be more active, and we'll go through it. What I'm going to do is I'm going to take you through like a day in the life of Mr. Hoffman, and how Friday went, and why Friday, in my mind, really perturbed me beyond what actually occurred. But I'm going to have to put it all in context. So we're gonna go through it. If any of you, it's not, I'm not trying to equate the two, but if any of you ever seen the movie Deep Impact, Morgan Freeman comes out. Tia Leone is the newscaster. Before the questioning period, he basically says, it's kind of complicated, so sit down and get comfortable. So this is going to be kind of a complicated scenario, but I want you to, I need to go through it so you can understand why at the end of it, I was perturbed. If I don't do it as I saw it, it won't make as much sense and impact. By the way, I'm on great terms with John Forster, so that just to let you know. I think Renee kind of threw a question out or a suggestion, whatever. At least I think I'm on great terms with John Forster. Perhaps he would say the difference. So I'm going to go through the scenario. We're going to talk. This is going to be very detailed. Have pencil and paper available because I'm going to give you some information. And if you choose, you're going to do things. And if not, you don't have to. Nobody's forced to do anything. Just I'm just making it available. Let's just say that. Of course, before I start ripping on to somebody, we're going to do a little fun, hopefully fun. Kind of, I tried to make the jokes somewhat similar. I try to match them to the topic to the best I can, which isn't very good most of the time. Life isn't like a box of chocolates. It's more like a jar of jalapenos. What you do today might burn your butt tomorrow. Another question I had, and maybe you guys have had the same question. You know, whenever you go to a psychic, and I'm sure you guys have gone to psychics before, why do psychics have to ask your name? I've never understood that. I think that's kind of a defect in the process. And even though this is a serious matter, we're talking about today, and I'm going to get into it's going to be very detailed. You're going to have to listen very carefully. You're going to have to put on your thinking caps very carefully. But even though that's the case, just remember, if the world didn't suck, we would all just fall off. And last, or close to last, what happened to the football player who went to prison? He used to be a tight end, but now he's a wide receiver. And last and not least, what is the proper weight for an attorney? About 3 pounds, not counting the urn. Anyway, before I start, just think where we are. So we've had this ridiculous, I'm talking about Gtii, if anybody didn't know that. Gtii, that fun company. So I'm talking about it. This has been going on. I think I got involved in late 23. I kind of figured out, not that anybody was going to pay me, nor do I seek remuneration for it. But I was thinking about this because this is why these tasks are so difficult to accomplish. I was just figuring out the amount of time I've put in, and I didn't count, by the way, per minute, just like general numbers. And I'm sure I'm in the millions if I'm charging fees. So just think about that. You needed, in whatever matter, you need a lot of, and it happens, you need a lot of people to donate a lot of money, and it's very difficult. And even if that happens, you don't necessarily get to the yellow brick road. The reason for, in particular, today's session is I wanted to state my concerns at a time when I think intervention can still occur to prevent anything from interfering with Mr. Forster's deal or any other deal. I think the iVersity deal is on the table. My concern is that if things are allowed to proceed as such, that what may go on might interfere with the completion of that deal. That's ultimately my concern. And that's kind of what everything here is based, because I don't believe unless a deal is done, then you guys won't be able to get compensated for your shares. That's what I believe. And I'm trying to, so whatever happens in the receivership is great, but ultimately I don't give a shit if a deal's not done because it doesn't get to the promised land. So my purpose, intention is to try to get to kind of present what's going on as I've promised. And I think I've done a pretty good job of doing that. And but give you enough information. And if you agree that further things have to be done, then I'm going to give you the opportunity to do that. And if you don't, then this is just a boring, long live stream on a Saturday. I would say it's not always the case, but on this particular matter, GTII, since late 2023, my spidey sense has been really good. When I got involved, I had no idea of the amount of corruption as defined by the receiver, but I was correct, and sufficient enough to help to get the receiver appointed, to get the old management out, to get action initiated. So that's been fine. Once the receivership has been in place, some of it's been good. And this is all my opinion. This is all. I'm an attorney, but I'm not a receiver. People can differ. I could be wrong, of course. I would say my record on this matter has been pretty good, so I feel pretty comfortable in whatever I say. But you don't have to agree with what I say. But I would say if you look back at my record about what I've said or predicted, I've been pretty good. So once the receiver got involved, I had less connection to the receiver, despite my suggesting all kinds of strategies that have been basically ignored, almost entirely ignored. I think incorrectly, by the way. I've had less involvement. The receivers appeared to be distant. Receivers Council is doing their own thing. And I'm not the only one who thinks that, by the way. So outside of the shareholder group, whoever these shareholders are today, outside of that group, there are multiple people that don't really understand what the Receivers Council is doing. And I've kind of, throughout this matter, and I certainly don't, and I strongly disagree with what the Receivers Council is doing, and I've stated that many times. But I'm not the only one. Multiple parties have stated that. And I've spoken to others who also weren't fond of the personality types at that particular firm. Multiple parties, not just me. So my experience is not unique. If you hear it from multiple people in different areas, then you have to take it as true. So I accept it's true. So I don't think very much of the Receivers Council, and the Receivers Council knows that, and they probably hate my guts, by the way, by this time. That's what my expectation is, because I've been calling them out on the rug. Just think about this, and I haven't got into this, so you have to be comfortable because this will be quite long. I haven't really. So my background, and I'm near the very end of my time as a lawyer, a practicing lawyer. I was hoping to be done sooner, and this has taken up a lot of time, but a lot of my time was in real estate litigation. And I've been involved, or certainly in the past have been involved in receiverships. And receiverships by nature have a negative connotation, at least in my mind, and to those who have experienced those. That is in part because, in large part, the receiverships tend to eat up the estate, so all the money that exists. And oftentimes, it's the receiver is an attorney. So in our case, we have a receiver and we have the receiver's counsel. The receiver gets paid, the receiver's counsel gets paid. Oftentimes, the receiver is an attorney, and the receiver hires the receiver's law firm as the law firm. In essence, double dipping. However, at least in that kind of situation, the receiver has some control over the law firm because it's its own law firm. In our situation, we have a receiver who gets compensation, maybe perhaps, and I'll throw this out. He's getting paid. I think he's supposed to get paid for doing the reports too, but apparently it's the lawyers who did the reports and charged for the reports, although they haven't provided the requested documents. So I don't know if we're getting two-timed on it. I don't know. I don't really know the accounting, but because the lawyers are drafting and getting paid, and I'm concerned about that too. I don't know about potential double dipping. I don't know. I really don't. But it occurred to me as a potential issue. Anyway, the receiver is involved. Once the receiver is involved, I've got disconnected from the matter. I don't think I'm the only one who got disconnected. That's my understanding. So, which also causes me more concern. Now, again, this could all end up great, wonderful. The receiver's counsel could be fantastic. They might have a deal on the table. Everything might be hunky-dory. But it wouldn't be appropriate for me to withhold what occurred. Would not be appropriate. And when you found out, you'll find out anyway. When you find out, you'd be pissed if I didn't disclose it. And it pissed me off so much that I can't withhold it. So I'm going to discuss it with you starting now, and we'll frame it. All right. So last week, I excoriated. If you recall, I went after the receiver. Oh, and by the way, so between the receiver and the receiver's counsel, I don't really have a problem with the receiver per se. I just think the receiver is inexperienced and lacks aggression. And again, whereas I said in my prior receivership experience, usually the receiver is the lawyer and his law firm is there. Here, the receiver is not connected to the law firm. So I think he gets pushed around by the law firm and he doesn't really control matters. My impression, and I could be wrong, my impression is that the law firm is really what's driving that. And remember, if I told you that Dylan Siciliano told me on one occasion that he drafted the entire 40-plus page report after I'd complained the report had been done. We spoke. He then indicated he was doing it and it was taking a long time, whatever. So that's the context. Now, I asked you guys to get pen and paper out. I'm going to give you some information now so I don't forget, and so you could use it as you choose or not use it. So if you recall, in this lawsuit, there was a plaintiffs group, and those plaintiffs group are represented by the law firm of Marcus Arbach, and I have nothing but good things to say about those guys. That's Alex Calloway and Chad Clement. I think those guys did a great job. They got it up to the point of the receiver. They're not involved in the post-receivership other than this kind of monitoring things from a distance. They know that, after I did this, that you guys would be reaching out. I didn't want you guys to kind of like bomb them with, emails, whatever, because I think they are doing and have done an exceptional job, but they know you're going to be reaching out to contact them. So I'm going to give you the general telephone number of 702-207-6069. That's for Alex Calloway, Chad Clement. That's for Marcus Auerbach. They represent, and this should be only for the plaintiffs. The plaintiffs group, the 250 people, if you're in that, then they are your counsel and you could speak to them. I've spoken to Alex and he's aware that he may get some calls. Please don't, overwhelm them. I have nothing but good things to say about them. But discuss it with them and see what input they might give you after you hear the entirety of this. Again, if you think what I'm talking about is BS or nonsense or not important, then just ignore whatever I'm saying and move on. If you want to contact the counsel for the receiver, the telephone number I have for them is area code 725-777-3000. And I think there's 3 attorneys that are involved. Dylan Siciliano, and his email address is dciciliano@gtc.legal. William Knoll, Knoall, I believe, and that's WNOALL at gtc.legal. And last but not least, Margarita Elias, and I've never had the pleasure of interacting with her, and her email address is MELIAS@gtg.legal. And again, and I mentioned it at first, please have all interactions, notwithstanding however you feel, all interactions should only be done in a civil manner. If it's not done in a civil manner, besides it's not ethical, moral, or legal, it's also bad for the position. We want to be perceived as being correct and not unreasonable. So acting in a non-civil manner will be interpreted differently by a court. So please keep all your communications in check. And I really mean that. It's important to me because it'll come back on me, honestly. And so those 3 people, I've had no contact with Margarita. I have spoken at times with Mr. Knoll. Mr. Knoll is a professional guy. I think most of his, and again, I don't know this for certain, so you could take it as you choose. Mr. Knoll, I think, has been involved in a lot of bankruptcy matters, debtor-creditor resolving issues like money issues, that type of thing, but not in the litigation standpoint, more in a negotiation standpoint. Mr. Siciliano is more the litigator and has been leading the handling of the litigation, which I've criticized. I'm not a big fan of his. He's not a fan of mine. I don't think he's treated me with any respect at any point in time. I've heard from others, their interactions were not quite as, they didn't have positive things to say either, just to let you know. So when I hear from other people, then I feel that my interpretation is not inaccurate. My own deal, I disliked him. Honestly, I disliked him from the start. I tried on multiple times to interact him, to get something going, and every point in time he just didn't want to do it. So that's why we are in the position today where I'm sitting here reading interactions involving the receiver and the receiver's counsel. So what happened is I bitched a bunch, and eventually, even though they didn't send it to me kind of in a passive-aggressive way, the receiver, quote unquote, last week sent and we did a live stream about this. So I literally went through the communication and I ripped apart the communication for various reasons. And there's a whole video, I think an hour. It's a 1-page email. And I spent an hour just ripping it apart, purportedly from the receiver, although I said from the language, obviously wasn't the receiver, it was from the receiver's counsel. But that's kind of lays the foundation. So I ripped them. They generate some response. They apparently sent it to several shareholders, although I didn't get it. I didn't get it. Maybe you got it. I did not get it. It's dated August 12th, the email that was sent. You may have got it at a different date, but August 12th apparently is the date. So we talked about it. Then after it, the next day, probably, I assume because I've been bitching at them so much, because that seems to be the only thing to get them to do anything, they set the deposition of Frank Benintendo. And Frank Benintendo, I believe, was a former officer and maybe, a side guy, not the main guy. A side guy, I think he's cooperative, whatever. I bitched about them. If you recall, I had bitched about them not going after Justine or filing a lawsuit based upon the receiver's reports. Again, all this is based upon the receiver's reports, not about what I think, just about what he says. So if he submitted reports to the court, I presume he thinks they're true and accurate. If they're true and accurate, I'm claiming that if you claim somebody did something, then you pursue relief based upon your assertion that he did something, because you have evidence apparently that could support that. So we went through this. They set Benintendo's deposition. I thought when they did that, I didn't say it out loud, but I thought, I'm hoping that this Benintendo deposition that they just set, that's set out at the end of August, but it's not really a date certain because it could be changed, but that they said I could attend to be upfront and offer. So I contacted Mr. Siciliano. I said, because I got a notice of the deposition, I said, I'm intending to attend. Can I do it on Zoom or appear in person, whatever. He was fine. He was cooperative about that. He said I could attend. I said I was just going to be an observer. So I have to give him credit as where credit is due. He was fine as to that, and I would expect to be an observer in any future depositions. But I thought the Benintendo deposition was like a side issue, and you still don't know if it's going to go forward. And I thought my concern was, is this like a bullshit tactic just to placate me? So it appears like they're doing something. So my thought in the balloon over my head, it says, are they doing something that's trying to make them look like they're doing something, but they're really not? That was my concern. So what I did after that, I started to draft an email, and I drafted an email, and the email was basically, in not the nicest way, but certainly accurately, questioning the tactics that had been used to this and suggesting alternative tactics. But I decided, and I showed it to somebody else, and they thought it was perfectly appropriate. So I felt okay sending it, but what I decided to do, as opposed to sending it, I decided to wait. And I was going to wait till Monday to send it, to see if additional filings would happen, and if I could get an understanding if they were not just bullshitting, if they were actually going to go forward. So Thursday late afternoon, I start drafting. No, excuse me, Friday late afternoon. So California time, 4:30 maybe. I start drafting an additional attachment to my email. And basically it says that what I was intending to say, maybe it's like 4:45. It was late in the afternoon, and that's important. The timing's important. But what I was going to say is, here's the email that I drafted a couple days ago. I was going to wait, and I didn't send it because I was going to give you the benefit of the doubt and see what happened. And here it is. So that's what I intended my email on Friday afternoon Pacific time around 4:45 to say. Lo and behold, at 5:10, I get something. And before I tell you what that is, I got to read for you what the email is that I was, because this is going to be important. That's why I told you got to listen carefully today. This is the email I was going to send, but I didn't. So here it is. I'm just going to read it to you because it's been sent and it'll make sense. So this is the non-sent email that I held till Friday afternoon at 4:45 p.m. Dear Mr. Strickland, as you know, I'm a shareholder of Gtii. Perhaps a beneficial resolution has been mediated with both Justine Reichman and David Reichman as to the return of all their shares. If that is the case, then you do not need to read any further. If that is the case, then I'm glad you were able to accomplish that. Then I leave a big space. However, since your recent email suggested that all material events would be reported in a report or SEC filing, and having seen none on this issue, I must reasonably conclude that it has not been successful to date as to the return of all of their shares, and then parentheses I state, as was an obvious expected result based on the manner relief had been pursued. I'm going to stop there. So what I meant by that, I said it was obvious that they weren't going to turn over the shares the way you were conducting yourselves. That's what I'm saying there, just to put it in English. But I didn't send it, and I was holding it off because I wanted to see what they were what to do. Continuing on, the email that I wasn't going to send as of the end of the day on Friday. This is not a situation where you were not advised of alternative strategies. For example, since day one, I have openly clamored that you file a lawsuit in California against Justine, parentheses, who you claim in your various reports, apparently not drafted by you and therefore inflicting large and unnecessary costs on the estate, that Justine engaged in gross misconduct and other such actions. As far as I know, and without any reasonable basis for not undertaking that action, nothing, I repeat, nothing has been done. How could that possibly be the exercise of reasonable judgment? Let me stop there. There's a business judgment rule in Nevada, and somebody like the receiver, if he conducts his affairs at a level of a reasonable business judgment, which is a fairly low level, then they're protected. So I'll leave it at that. Continuing on, although it may be too late, the appropriate thing to do is to immediately file an action in California and aggressively and without unreasonable restraints pursue appropriate provisional remedies against Justine and Gtii's property. So I've said that for months. I've not heard even if there's been resistance to a lis pendens, writ of attachment, there's been no explanation why no lawsuit has been filed. Zero. And that's what I'm trying to communicate here, but I wasn't going to send it. Remember? I drafted it to see what they were going to do, and I held off sending it. Continuing on, and this is very relevant. You'll see why this is how relevant this is, especially if resources are now thin. See below. There is also no more time wasting as to deposing David Reichman. I've been calling out for this publicly for months. Based on your reports, I suggest it would create an unusually difficult position for David Reichman. Would he be advised to take the fifth with litigation benefits inuring to the state? In other words, coming to the benefit of GTII, or would he perjure himself and or make a defense weaker? No matter, this has been a strategy inexcusably ignored by you. Then I suggest the attempted solution: depose him now. And just think about what I just said. So I'm in this email that I didn't send after they pretended, in my mind, to take aggressive action by Benintendo, and I was just feeling it. I didn't have any reason. Nobody told me. I drafted this email because I didn't trust them, honestly. And in the email, I'm calling them out for their tactics. But I didn't send it because I wanted to give them 2 days to see what happened. I'm going to continue. I'm going to read it again. Okay, here I'm going to continue. I've heard disconcerting reports from shareholders that the estate. I'm stopped there. Yeah, some people have, shareholders reach out. I don't remember if it was email or contact. I don't remember who it was, but they've been told that the state's low on funds, and that might be the reason why they don't pursue Reichman aggressively. And I don't know why they would be low on funds, why they hadn't pursued Reichman aggressively. Since I've been calling it out since day one. Completely inexcusable, but just remember that they said that, or that I'm saying that, or raising that as an issue, because they've told various people that apparently that's their, and maybe those people weren't accurate, maybe those people misinterpreted, maybe I have misinterpreted what they said. I don't really think so, because I think I've heard something similar before also, but perhaps they're concerned about the finances and they're being a little less aggressive because they're concerned about finances. Now, why they didn't take aggressive action from day one, as they should have, no explanation. But Be that as it may, that is the case. I've heard disconcerting reports from shareholders that the estate, despite collecting substantial sums, now claims it may not have the resources to pursue the obvious strategies that were publicly and repeatedly suggested. In my mind, if that is the position you take, I would not be able to accept that conclusion without at least considering potential remedies. Not a very kind statement on my part. But I'm basically saying if you fuck this up so much that you spent the money on bullshit stuff and you didn't do what was suggested by us, then you got problems. That's what I'm suggesting. You could think differently, by the way, and I could be wrong, but that's what I'm suggesting. And part of it is because I don't get any feedback. They don't clarify anything, as you will see. I even gave them a chance to clarify things as this plays out. I'm aware of I'm continuing on to the email that I wasn't going to send, that I drafted after they set Benintendo's deposition, me not trusting them, but letting it play out. I am aware, again, so when I drafted this email, I didn't send out. And when I told you I had good spidey sense on this case, this email, when I get to the end of this, you're going to understand why my spidey sense feels even better. I should get my own mini-series. So please, if anybody producers out there, Born Free Film, set me up. Okay. I'm aware of I state, I'm aware of the business judgment rule, which I just mentioned. Even as the issues raised herein, the choices, now parentheses I say, when tied to the expenditure of monies are not reasonable nor justifiable. Clearly, if you had pursued the obvious strategies suggested with vigor, the case would have been over by now. You still have the opportunity to attempt and mitigate those errors. I have again laid out what needs to be done. If I can provide any further background or information to carry out your duties, please let me know. Thanks, Richard Hoffman. And I leave my email and telephone number. But I didn't send it because I was going to wait and see what happened. So end of Friday, I'm starting to draft because I haven't heard anything after the Benintedo. And I'm starting to think, well, maybe I was right. Maybe there was this bullshitting about really having any kind of vigorous action. So I start writing an email, which I was going to send on Monday. And the email was going to, as I said, when we started this, it was going to say, I held off sending this. I wanted to see what you were going to do. You didn't do it. So here's what the email says. And then I resuggest the tactics, etc., because that's what the email that I just read to you says. While I was drafting that email, I got, I drafted it. It wasn't a final. I got off it. I looked on my email, and on the email, I saw a notice of a filing that was made at 5:08 p.m. So just think about this. I'm going to read something for you. So remember that letter that I mentioned August 12th, where the receiver purportedly writes it, and he's basically responding to make everybody happy and say that everything's going to be great. So two things I just want you to think about when I tell you about the next document. This letter, and I don't know what this would constitute, what type of liability, if any, there is for these statements, but you could judge it accordingly. So one of the things they said, to ensure fairness and uniformity, the receiver communicates all material information through formal receivership reports filed with the court and through the company's SEC filings. So that's what they say. One, yesterday I didn't receive any reports, and I looked online as to SEC filings. I did not see any filings. So that's that. So they say they communicate all important material information through either reports or SEC filings, and I have not seen any of that. The next paragraph refers to the first sentence of the next paragraph. Transparency remains a priority. Okay. If there was anything else I wanted to say. Oh, and last but not least, oh, and I got two other points. The other point, and we talked about this, as reflected in the receiver's interim reports, GTII, just think about it. So this is August 12th. Think about this. I really want you to pay attention to this, because this is going to make your pants drop when I put it in context. As reflected in the receiver's interim reports, GTII has minimal assets and faces significant challenges that makes its future prospects uncertain. That's stated, remember that. And last but not least, remember this. Foremost, though not required by the receivership order, the receiver will ensure that settlements and releases of all claims against former officers and directors will be subject to approval by the court overseeing the receivership proceedings, and that the general terms of such release and settlement agreements will be posted on Edgar and the company's website. We understand the concern shareholders have and remain. This is the part for the bucket. We understand the concerns shareholders have and remain committed to managing the receivership process fairly and transparently within the framework established by the court. Thank you for the engagement. So there are two references to transparency. One reference to everything's going to be on a report or on a filing. One reference to minimal assets, and one reference to court approval of everything. So just remember that. This is the document I ripped up. Again, put it in context. I'm pissed for a lot of reasons. Don't trust the receiver's counsel. Call them out. Receiver pretends to draft a letter. I call them out. They set Benintendo's deposition. I draft an email I'm not going to send. I start drafting another email, basically a cover email for the email I hadn't sent. While I'm drafting it, I get a notice on my email of a filing. The filing is a stipulation and order that's already been entered. So parties got together, the parties being the counsel for David Reichman and the receiver's counsel. They got together and they agreed without disclosing it to, they certainly didn't disclose it to us. It wasn't referenced anywhere prior to this filing. It's not been filed as a receiver's report. It's not referenced on the, as far as I know, it's not on the company's website. I checked today, it was not as an SEC filing. But between the receiver and the counsel for the receiver agreed with David Reichman and David Reichman's counsel that that GTII will release to David Reichman for his use to hire counsel just one time, $20,000. So I'm concerned, just so again, putting in a sequence. So I don't trust the receiver's counsel. I prepare initial email. I hold off seeing what he's going to do. I start to draft a cover email. While I'm drafting the cover email, questioning his tactics, they file after hours and a stipulation, an order that's already been signed by the judge, releasing $20,000 to a guy the receiver claims has engaged in misconduct beyond to use as for legal fees against the estate, to not only deplete the estate of money, but to also force the estate to pay money in defense of those monies. So who benefits from that? The only person that benefits from that would be receiver's counsel, right? Because if there's any monies left over and Reichman can now defend himself against the estate, then the estate would have to oppose that. If Reichman didn't have money, then how is he going to defend himself? If the justification for not litigating this is that the estate was concerned about spending money, then they don't get it. They have no idea what's going on. They're completely lost. They're doing nothing in the interest of shareholders. They're not our friends. So when I saw that, I flipped. It's not the amount of the money, $20,000, although it's not 20,000. That 20,000 is going to turn into a much bigger number. It's that these guys don't get it. They're not our allies. They're not trustworthy. They've not done anything to show that they're trustworthy. We cannot accept them acting without intervening. We cannot. They don't deserve it. It's not justified. You need to express yourself. So, after receiving this order and almost passing out, I restarted my cover email because, again, I was waiting to see how it was going to play out. And oh, by the way, how transparent was it that they filed it after hours? How transparent is it they didn't let shareholders know about it, period, beforehand? What is the basis? Would you give Bernie Madoff money to defend himself? I mean, I don't think Reichman is, according to the receiver's reports, maybe the scale's different, but according to the receiver, is David Reichman any better than Bernie Madoff? Seriously. And if these guys don't understand that, then they certainly are not operating in the best interests of the shareholders, any shareholders, and they certainly can't be trusted. How could you trust these guys if they don't get it? By the way, I've suggested the opposite strategy. They're taking this strategy, a capitulation, expenditure of all money, and then probably bail. So after I get this order and after I just almost exploded, honestly. So now we're about Pacific Coast time. I look at the order. I wander around a little bit. I think about it. And then I look at the stipulation. I then go back to drafting my email. Oh, and I went back, by the way, one additional thing. So remember that August 12th letter, the receiver says, however, and I'm just going to read it. This is from the receiver. So is this, I don't know how you reconcile. I just don't. August 12th, as reflected in the receiver's interim reports, GTII has minimal assets and faces significant challenges that makes its future prospects uncertain. So the way I read it, the receiver is saying they have minimal assets and that puts their prospects, makes them uncertain. And 3 days later, they're giving $20,000 to Reichman and exposing the estate to a potential additional fees that will only benefit Receivers Council, nobody else. That is it. So this letter is bullshit. Now, I went through it before and I indicated why it's bullshit, but how can you reconcile the fact that you have minimal assets and then give money away to Reichman 3 days later? How the fuck do you reconcile that? Not reconcilable. So, to put everything in proper perspective, because I'm a fair guy, I am. Unlike everybody that we deal with, almost everybody in being a retail shareholder, almost everybody that we deal with in some fashion fucks us or often fucks us or is not trustworthy. Honestly, if you look back, a whole series of people did not look out for our interests. Theoretically, these guys are supposed to look out for interests, but they have no, again, just my opinion, I don't think they have any interest in that. And nothing based upon my experience and what I'm talking about today should give you any different feeling about that. But I'm a fair guy. So after I get this order and before I finish my cover email, because I don't want to misspeak and I want to give them an opportunity. So I think I see the stipulation order at 5:10 Pacific time. And is it 5:10? Something like 5:10. I don't remember exactly. Maybe it's 6:10. Maybe like at 6. Yeah, it was, excuse me. I see it at 5:10. I, stew, walk around. Maybe I start scribbling more. And then I decide, you know what I'm going to do? I'm going to be fair about this because maybe there's an explanation. So at 6:17 p.m. Friday night, August 15th, isn't that a great way to spend your Friday night? I send an email to Paul Strickland, Dylan Siciliano, William Knoll, Margarita Elias, and I copy, because I love him so much, little JR. It says, and it was sent, received, I know, by all those people. Dear sirs and madam, if you have an explanation to supplement the filed stipulation and order for your agreement to release $20,000 to an individual that the receiver claims engage in all types of misconduct and thievery, please do so by 8:17 p.m. Pacific tonight in an email form. Please only address any rationale for agreeing to the stipulation in light of what is asserted by the receiver. Next paragraph, I've not seen an 8K, just checked, nor a report nor explanation from anyone justifying the same. I find the agreement to the release of funds to be completely and entirely inappropriate and contrary to the interests of the shareholders, parentheses, based on the facts disclosed by you to date, close parentheses. Your recent email to some shareholders jokingly asserts that transparency is paramount. Now, you do a private, out-of-sight deal to assist someone who the receiver seemingly accuses of engaging in what appears per the allegations to be claims of felonious misconduct. Thanks for your attention to this matter. Sent at 6:17 p.m. So during that time last night, I drafted the cover email and I fiddled with it for a while. And, I thought about it and fiddled and I wasn't sure I was going to send it. Wasn't sure if I was going to wait till Monday. But I was so appalled by all the inconsistencies in the language, inconsistencies in what a letter says and what they do, lack of transparency, lack of communication. And that's just not me. That's others outside our sphere. So this is not a singular issue. And if you recall, I remember even when this litigation started, this office of the counsel of the receiver, they did dicked around about the scheduling. My recollection, they dicked around about the scheduling of a deposition, not even had the courtesy to ask opposing counsel, co-counsel or side counsel about it. That's my recollection. So but notwithstanding all that, I still gave them the opportunity to respond. So I waited on a Friday night. I sat in my stupid office and waited because I said I'd wait 2 hours and give them 2 hours. And, could their argument be, well, it's late? Well, they filed their stupid stipulation and order after 5. So couldn't be that late if they filed their stipulation order after hours in such a transparent manner. And again, that's another factor that causes me to be distrustful of the receiver's counsel, is doing dick moves like filing things at after hours on a Friday night, like you do in DC. If you were hiding bad news, like on a holiday weekend on a Friday night, that's when the news comes out and gets buried. By the time Monday comes around, nobody knows about it. You think that the receiver's counsel might think that if shareholders found out that they had released $20,000 for Reichman to use for defense costs, that they would have liked it and they would accept it with open arms? You think that might relate to why they put out that stipulation order after 5 p.m. on a Friday night? How deceptive and lack of transparency is that? How disgusting is that? Anyway, but notwithstanding that, listen, that's the side. But notwithstanding that, I gave him 2 hours. I think I waited longer than 2 hours, by the way. I decided that even though I said I'd wait 2 hours, I would wait longer than 2 hours because, maybe they'd be 5 minutes late or 10 minutes late or 15 minutes late or 20 minutes late. When it got to be 2 hours and 20 minutes at 8:39 p.m. last night, I responded even though I wasn't intending to respond because I was going to let it play out till Monday to see what they were going to do. But I saw what they were going to do at that point in time. And at that point in time, I responded, and I'll read you the response. And at the bottom of this email is the email I started this stream with, where I read that I didn't send, but that's the email is at the bottom. So I'm showing them what I didn't send, where I'm criticizing all their strategies and what they were doing, but didn't send to wait to see what they were doing. So here's the email I sent last night at 8:39 p.m. Dear Sir, and this is directed at Paul Strickland, copied to Little JR. Dear Sir, I wrote the email below a couple of days ago. I held off finalizing and sending it to you, trying to be fair and see what action you would be taking. In light of what happened today, I'm forwarding it to you in its raw form. In other words, I'm referring now to the email that I didn't finish that's attached to the bottom that I read to you at the start of this live stream. At the time I decided to hold off sending the email below, your counsel had just noticed Frank B's deposition. Although I was skeptical, I waited to see if you would move forward in a manner befitting the contents of your lengthy reports accusing various individuals, parentheses, apparently prepared by counsel, not you, with a commensurate huge expense, close parentheses, with detailed accusations of misconduct and thievery. Next paragraph, and in bold. 100% to the contrary, instead of taking action today, and then parentheses, deceptively, I only got notice after 5 p.m. on a Friday, you gave David Reichman $20,000 to use against the estate and shareholders, which will require the expenditure of additional significant sums to defend. This further dissipates estate proceeds needlessly. Further, as it was a private transaction, you did not give any notice to shareholders beforehand or when it mattered. Despite that, again, before sending this entire email, I gave you and your counsel more than 2 hours to explain or provide any rationale for releasing $20,000 to someone you describe as having engaged in improper and potentially felonious misconduct. None was provided. Next paragraph. If the estate can afford to just give away $20K to be used in legal proceedings against it, and therefore generating further costs and fees for the estate and for the benefit of the receiver's counsel, then the estate must have sufficient proceeds to properly litigate this matter. If the receiver and his counsel have wasted precious monies on nonsensical and non-productive strategies, that is on them, and collectively you should correct it on your own dime. Next paragraph. Before actually sending this, I thought and hoped that finally your chosen counsel would move forward in an obvious path disclosed publicly repeatedly. Finally, I expected that an action would be initiated against Justine based upon what you assert in your own reports. I've been calling on this for months without any reasonable, prudent, or logical explanation for you not doing it. How could you justify suing Astra on a matter involving possibly $250,000 while sleeping like a hibernating bear against those accused of misappropriating millions. The obvious strategy was to squeeze all bad actors, including, obviously, David Reichman, by deposing him immediately. Based on the contents of your own reports, it was clear that Reichman would have to take the fifth or commit perjury. So I held off sending the email below, hoping that, in my opinion, you would finally do what was really needed after apparently dissipating a significant amount of funds undertaking foolish strategies. As there has been very little clarity offered by the receiver or counsel, apparently operating in the dark shadows, when I saw that you had released funds voluntarily to David Reichman late this afternoon in a seeming underhanded manner to pay his lawyers against us, that was it. Previously, I asked for all legal invoices. I again demand those. Next, please provide the identifying information, policy number, and contact of any liability insurance currently maintained by Gtii or in which Gtii is an additional insured, or for related parties or individuals. Finally, the contents of the email below, that email that I read to you when we started this, are even more relevant in light of your unexplained and painful actions of today. Do the right thing. Don't be responsible for killing any deal with AI-versity. Are you trying to kill that deal like you allege in your reports that David did with GTII? And then last, I say, don't charge the estate in responding to this or justifying your and counsel's actions. In other words, they'd respond to this and charge us for justifying what they did or didn't do. Thank you for your attention to this matter, Richard. And then beneath it is the email. And again, my position here is solely based on what the receiver puts in his reports. I have no idea the truth of the accuracy of what his allegations are, but he submitted those to the court. If he submitted those to the court, either they're truthful or he committed perjury. I assume they're truthful. If they're truthful, and there's no justification for not having gone after those parties. None. Zero. Makes no sense. I threw out that Astra. Think about that. July 22nd, 2025, on a matter involving at most $250,000, they sued Astra. They haven't gone after Justine, nor have they taken David Reichman's deposition, nor have they done anything of substance in litigation. They have, as far as I know, they took a preliminary deposition of an entity that Justine was associated with, but he didn't disclose the time, or they kind of went forward without properly scheduling it, which pissed off me and counsel, by the way, at the time, which kind of was another indication about receivers counsel. But so they did that, sent out a bunch of subpoenas. I have to give them credit for that. They've been in court and they've collected fees. They have gotten back some money and some shares. They've gotten paid. They've collected fees. They've been in court a few times. They got paid. They got some fees. I think that's kind of sum and substance of it. So brings us to what I'm going to ask you guys for. So I give you a bunch of information, numbers, places. If you agree that what is going on seems out of the ordinary, and by the way, since this, I have run this by other legal mind, and they don't understand what's going on either. So I'm not unique, and I'm just going to rely upon my spidey sense, non-disclosure, interactions with the parties, this after hours, whatever you want to call it, and what the receiver puts in those reports, which we base all this stuff on. So either it's truthful or not. If it's truthful, then no excuse for not having undertaken actions. If it's not truthful, then they have different problems. And if you recall, one additional thing, Dylan Siciliano told me that he prepared the 41-page report, not the receiver. And I haven't seen the bill, but I'm sure the bill was sizable. The receiver, I believe, is supposed to prepare the reports. I don't know how many reports he's actually prepared. It's not that the counsel can't review them, but the receiver is supposed to prepare it. So if the receiver is getting paid and compensated, but the counsel is getting paid and compensated, is that double billing, double payment? I don't know. But it's something to be discussed, right? And that's one of the reasons I asked for the invoices. I got to see who's billing for what, who's getting paid for what, how much they've gotten paid, and with very little actual litigation, in my opinion, to date. Bunch of reports, those are great. And again, that's task stuff. So you can do a bunch of tasks. I don't give a, I care less about the tasks. If we don't get if we don't get a new business and trading, then all those tasks are bullshit. And then the lawyers have just made a bunch of money. Usually nobody would press them on this. This is unusual. That's why they hate me, by the way. If something happens to me, it's because somebody over there got pissed off enough. So I'm saying this now. Something happens to me, it's because somebody I'm talking about didn't like this. So just putting that out there. But who knows? I have no idea what's moving this. Is it incompetence? Is it fear? Is it money? Is it influenced by outside parties? Is it a combination of them? Is it somebody's in a stupor? Is it that I don't know. I have no idea, other than that makes no sense that someone who has leverage has completely abrogated that part. It makes no sense. So somebody who has somebody by the balls is acting like somebody has them by the balls, and has acted that way since day one, despite in the report saying 100% to the contrary. Makes no sense. So, I've said it enough, and I've kind of done a series of live streams where I've indicated my concerns about the receiver's counsel and the receiver too. Obviously, if the receiver is not capable of managing his own counsel, then what good is he? And if the receiver, like I said, is the receiver supposed to prepare reports? Because that was my understanding. The receiver's not preparing the reports and counsel is, and they're charging us tens and hundreds of thousands of dollars to do that, then are we getting double payment, double billed? Something to consider. So I just gave you a bunch of emails and cocktail information. If you're unhappy with what's going on, I think you should communicate it. If you think everything is okay or you don't want to participate, then so be it. If you're unhappy, then communicate it in a civil manner. Now let's go one step beyond that. I'm one guy. I spent a shitload of time on it, but I have so much influence. Not that I mean I have so much, but I have only so much influence, proper grammar. And I'm not admitted in Nevada. So what I do is I obviously have kind of tried to point out what's going on at all times, keep you in the loop so you're not on the outside. Because imagine you didn't know all this stuff, right? You wouldn't know any of the stuff all going on. I'm not slapping myself on the back because we haven't made it home yet. But if somebody like me were not involved, this company would have gone out of business and everybody would have stolen the money, according to the receiver. We're not at the end, but that's what required somebody intervening. So I've kind of laid it out and tried to be a guide, but I can't do it alone. And there are shareholders out there, people who are watching, I'm sure, who either have large amount of shares and have a lot to lose or have lost lots of money or have some bucks. And if you guys, a group of you can get together and I'd help you find a lawyer in Nevada, and I would work for free with that lawyer to kind of bring them up to speed, and they would represent every other shareholder not in that group. So, there's a derivative group of 250 shareholders. So this is another group of shareholders, not the derivative group, who are acting independently, may have obviously have the same goals, but acting independently. But it would take hiring local, and I'm not going to tell you because I haven't decided, haven't looked into it, whatever, decided to throw it out. But we'd hire some local counsel to participate in proceedings, take whatever actions necessary with regard to the receiver and the receiver's counsel, assert proper objections, and really make a stake in court against the receiver and the receiver's counsel. Now, I can do things, but again, my other than being educational and perhaps impactful in getting some activity, I don't have any. I don't have any great power in the court, and it really would take somebody who's local counsel in Nevada. So, if a group of you want to get together and amongst yourselves, and get a pile of money together, then I don't think it has to be a huge pile of money, but get some pile of money together. Then you could reach out to me, and then we could try together to find counsel in Nevada who could, try and protect the interests directly of shareholders. Because again, in my mind, nothing I've heard to date gives me any indication that the receiver or the receiver's counsel really has any interest or concern about shareholders. Nothing. And, I gave them an opportunity to kind of set it straight. Like, they could have told me, for example, a reasonable I could imagine this discussion. I was kind of expecting this discussion. Richard, the reason why we capitulated to give him $20,000 because if we had to litigate it, it would cost us more, and the receivership doesn't have a lot of money, so we didn't want to do it. And I would have said, you're out of your mind, and you don't understand this case, and a bunch of expletives. I would have screamed at him. And I would say, you obviously don't know what the F is going on here. Really. I mean, I would have been so astonished. But no, they didn't respond even that way. Because money is, that it cost the estate more money to not give Reichman money to use against the estate and cost the estate money. That is lunacy. Maybe you disagree. So anyway, bunch of you get together or not. If you don't, I'll continue doing this. I'm just saying that we would have a higher likelihood of success if a group of you get together. I will certainly, lay whoever straight, give them as much information as possible and guide them. But it would really be nice to have the existing other shareholders intercede and assert their position and assert their stance against the receivership, if that's what you agree. If you don't agree, then I'm full of shit, and that's wouldn't be the first time, won't be the last. But I feel pretty comfortable. It went on just Friday night that my concern was well founded, and again, doesn't mean that the case might not end up great, whatever. But I don't think we could trust from this point forward the receiver or the receiver's counsel. And if we do, we deserve what we get, honestly. And I think to the extent we can intercede, we should intercede and protect any deal that might bring us trading again. Because again, my ultimate concern is that the way they're managing this, that they'll blow the AI-versity deal. And if they blow the AI-versity deal, then what are we talking about? In the discussions with counsel, also, when I threw out getting a group together, it may be the case also that funds might be retrievable either from the receiver or from the receiver's counsel, if it is appropriate. I don't know at this point in time, but that might be a way of funding any type of litigation, or it might be an alternative source of litigation. There might be malpractice insurance, might be liability insurance, things like that. But I really thought that what went on after hours Friday, that was it. Literally, that was my end. No more. That was it. You can disagree. If you agree, join on board, take action. At least let them know what you think in a civil way. And again, if you want to put a group together and I can manage you, I can help you find an attorney and probably shorten the time and money that it would cost to expend, because I could spend a bunch of time educating them on this. If you're interested in that, I'm happy to facilitate that. If not, then that's fine too. But anyway, I thought it was important enough and obscene enough, and clearly doesn't get it, that it needed to be brought to the attention of everybody. And that's where I'm going to leave it. So for all of you, I appreciate you hanging out here for about an hour and 10 minutes. Feel free to post any comments. Again, all this is based upon the 4 reports of, well, allegedly from the receiver, but it's, we know at least one's from the receiver's counsel because he's told me. My guess is maybe all are from the receiver's counsel, or at least, mostly from the receiver's counsel. But whatever I'm talking about here is based solely on that. And whatever I've spoken about throughout this, I've been very careful to make it based upon what the receiver said. If the receiver is not accurate, then that's a problem. But I presume the receiver is accurate, and that's where we leave it. So look forward for people reaching out to me. I'm going to leave in, should I leave it? You know where to get a hold of me if it becomes a problem. So you could reach me on Twitter, etc. Post it. If you have interest, you could reach out to me. If it becomes a problem in terms of communication, let me know and we'll work out something else. If you're not interested, you don't have to be interested. Nobody should be compelled. And I mean this 100%, by the way. I was speaking to somebody about this. When I say or suggest something or have a view about something or an opinion about something, I mean no, and I really mean this. I don't mean to manipulate or try to convince. I'm just pretty certain about my views, and I'm arguing it like I would argue it. If you don't agree, I take no offense. If you don't follow through, I take no offense. I just thought this was a appropriate time that where people needed to step in, take active action, and assert themselves. If not, and that would be the best chance at getting a positive result. So that's where I'm going to leave it. I will check all comments. I will check Twitter, etc. If you have questions, feel free. And everybody be well. Take care. Have a great day. And talk to you later. Be well.